Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Pilta and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Happy Thursday. Happy Thursday, everybody. Today's Thursday, July 16th, 2026. Oh, wait a second. I got to switch to the Ethernet. Hold on. Let's hope that StreamYard is a little bit better today. Last night it was a mess. It was an absolute mess. People were getting kicked off left and right, and it was like a whole thing. It was a whole thing. Sorry I'm late. I had people banging on my roof all day, and I thought, surely, since they were here since 7 a.m., they would be done by 3, but they weren't. They were literally just banging up until 5 minutes ago. And now I have a wicked headache. And I was like, do I really want to do this tonight? Because I'm going to get a bigger headache doing this tonight. And then I was like, yeah, I have to do this tonight because it's not going to be done in one show. Because I fell into the rabbit hole today. And there's a lot to talk about. Because there's a lot of other people who may be a little bit more involved in what's going on here than we thought. And also I thought there's a lot of people here who don't know the lore, who don't know all the stuff that happened before Karen Reed and the depths of the corruption that has been going on, not just in the county of Norfolk, but in the whole corruptachusetts for decades. And you guys know it. I don't even know where to start because I found so much. But hold on, because let's just do our quote of the day. Let's do our quote of the day, our motivational quote of the day. Dr. Mae Jemison. I looked her up. She was the first African-American woman to travel into space when she went on the Space Shuttle Endeavour in 1992. Anyway, Dr. Mae Jemison said, never be limited by other people's limited imaginations. How do you like that? Never be limited by other people's limited imaginations. Isn't that great? There it is for Thursday, July 16th. All right, there it is. The fallout from Karen Reed and Sandra Birchmore has brought a lot more people into the mix. And many of you watched with Andrea Burkhart the post hearings with Robert Devine and Robert Devine's testimony. I have some of that pulled up for you today. But it made me think when I was listening to Grant Smith Ellis do his interview last night on Justice Served, which I linked in the show notes below the video. Did you guys go and watch it yesterday? And he brought up Tiffany Overstreet, and it reminded me of when I did my deep dive into that situation with Robert Devine a very, very long time ago. And I thought maybe a lot of you would not have heard about that story and Robert Devine and all the craziness that went on in the Stoughton Police Department before Sandra Birchmore, when Sandra Birchmore was just a young girl. And Robert Devine was the head of the Police Explorers program. And he met her when she was like, I don't know, 12, 13 years old. And there were some shenanigans that went on in 2014 with Robert Devine. And there's a long history of cops covering for other cops in Stoughton, in Norfolk County, and others. And so we're going to go back to 2014, and then we're going to move forward from 2014. And remember, Proctor's phone extraction goes all the way back to 2012. And I've been saying this since I started covering Karen Reed's case in January 2024. What happened to Karen Reed beginning in January of 2022 goes far deeper than Karen Reed, because if she takes a plea, it's over. If not, it's going to be a whole other episode. Well, not just an episode. It's been 2 seasons. We're on season 3. Season 1, Karen Reed's first trial and all the pretrial that came with it. Season 2, Karen Reed's second persecution and her acquittal. Season 3, all of these civil cases and the mishigas of litigation that's now happening for wrongful death, defamation, violation of Karen Reed's civil rights. Season 4, who wants to start writing the arc for that season? Because season 4 is going to be the takedown of the corruption and a couple people in some silver bracelets. And a bunch of dirty cops do not make the thin blue line. That's right. There are good cops. Nobody hates a good cop. Nobody hates a bad cop more than a good cop. So we don't generalize about all cops here. Oops. Because Scott'll send you packing. Because he did 25 years on the job, as you can see from his handle, from his YouTube handle. Look at that. Holly is actually going to Block Island this weekend for a week-long stay. That's amazing. You're going to have a great time. Have you been there before? She says, no need to send me there. Thanks for your 10. Thanks for your 10. Oh, I'm glad you bought the whipped tallow. It is lovely. It is a lovely moisturizer. It is a lovely moisturizer. Is it supposed to be gritty? I don't know. Warm it up in your fingers and it won't be gritty anymore. If it sits for too long, it can get gritty. I don't know. I don't make it. I just like it. Thank you, Coca, for being here for 8 months. And also, Better Letter Rose by Better Rose, been here for 2.5 years. Thank you. Many of you probably know a lot more about the lore than I do, because many of you have been following Turtle Boy for years. And so I look to you to assist me with some of the facts here, because it's insane. Emma Louise, thanks for being here for 7 months. And oh, thank you so much. Thank you so much. It's the whipped tallow. I love it. So, well, let's pick. Do we pick an affirmation for a badass? No, we didn't. No, we didn't. The hearing this morning, I mean, the status conference this morning was like 10 minutes long. By the time I found the right Zoom link, I think it was already over. So they never even let me into the Zoom, so I didn't get to hear it. But it's out there. It's 10 minutes long. I'll give you the quick and dirty lowdown, because I really don't feel like watching it right now, if you don't mind, because I have this whole other thing planned. Oh wow, this is timely. Ready? Badass affirmation for a badass. You guys ready? Whoever is trying to bring me down is already below me. Got that? Whoever's trying to bring me down is already below me. Read the card and weep. There it is. There it is. Are you watching it on Grant's channel? Good. Good. The dirty lowdown on what happened this morning at the 10-minute status conference in the wrongful death case of O'Keefe versus Karen Reed. 12 depositions have been done. There is apparently going to be a deposition every single day in this case until August 17th, which is the cutoff for discovery. Can you imagine? Every single day from now, July 16th until August 17th, there's going to be a deposition. I mean, what? That's insane. How does anybody have the chance to have any other cases? The plaintiff's firm is going to go bankrupt because they don't get paid until if and when this case settles. And I don't think it's going to settle anytime soon. If ever, I don't think it's ever going to settle. Actually, Judge said he thought he resolved all the pending motions to compel the witnesses to appear for depositions. Rosenberg agreed. Diller confirmed everyone's been subpoenaed. He doesn't think there's going to be any more attendance issues, Diller said. So Karen Reed's team has done 6 depositions plus some of Proctor's. They have maybe at least 9 more to do. Waterfall has 3 depositions scheduled, and they don't have anything to report as far as issues getting people to show up. CF McCarthy's 4 are scheduled for late July and August, and she says that everyone's so far been cooperative. And Diller has done 12 depositions. I don't know if that means 12 altogether or he's just done 12. And depositions are scheduled every single day until the end of August. I guess Judge Gilday asked if anybody's going to be filing any motions for summary judgment or any motions to dismiss. Sounds like the bars and Reed's team, they're all going to file motions to dismiss at some point, depending on what they learn at the rest of the depositions. And there's some sort of, they're supposed to be getting together a privilege log, and they're having some issues getting that together, but Gilday encouraged everybody to keep working to try and get that done. So that's about it. Yeah, people were saying that Diller talks so slow. So slow. He's like, you got to put him on 2 times speed just to make it sound normal. Right? All right, let's get this on. Let's get going. First order of business. Come with me, if you will, all the way back to 2024. I don't know. They didn't talk about the dates that people were going to be deposed. So, and we're just wait and see. We're just going to wait and see. Let's go back, because I remember when I first started covering Sandra Birchmore with you, I received the entire public records request with regard to Sandra Birchmore that Dave Cullinane from Barstool Sports had actually requested back in October of 2022. Yes, we covered, hi MPB, we covered that yesterday, Sweet Pea. We covered Carol Erskine's comments regarding Judge Gilday yesterday. Yeah, she's a great judge, a wealth of knowledge, and she had the same thoughts that everyone else had. No, don't know anything about Karen's phones. Nope, haven't heard about it. Anybody else heard about it? Nope, he didn't extend the deadline for discovery. Nope. Lily Rose says, for those wondering why our Attorney General and Governor haven't opened cases on all of these people, it's because Governor Healy is very good friends with the MSP and the Norfolk County DA's office. Michael Marcy. If you put foul language in the chat or dirty words, they're going to get deleted. I'm not going to have my channel stricken because people can't control their language. So please don't do that. Thank you so much. Appreciate you. Yeah, Emily, it's almost like Karen's side is nothing to hide or dodge from. Nope. Nope. Thank you, Tina, for thanking me. I appreciate you so much. Oh, this is interesting. All right, good. Thank you for getting us back on topic. Kristen Anderson says, where do I start? I live in Canton, graduated high school with Jen McCabe in 94, and Robert Devine was a few years ahead of me in Canton High, too. Yep. Okay, can we move on to the topic that I want to talk about today? Would that be good? Can we do that? I'm going to lay some knowledge on you, and you might be shocked if you haven't heard about this stuff. So let's go to this, because as you know, Sandra Birchmore was killed in early February of 2021, almost 1 year to the day prior to the murder of John O'Keefe. And Sandra Birchmore's death was quickly ruled a suicide, despite everything pointing, no, that's not the right thing. That's the wrong thing. Despite everything pointing to it not being a suicide. Sandra Birchmore was pregnant. She was very happy to be pregnant. I think she had laundry in the washing machine. She told people that she was very happy about her pregnancy. And she was killed at her apartment in Canton. And so Canton PD was the first to respond to the scene of the murder of Sandra Birchmore, which they quickly ruled a suicide, despite the fact that they had her phones, they had all these communications, they had video of Matthew Farwell in the lobby of her apartment building the same day that she was murdered. Guess who else spoke to her the same day that she was murdered? Robert Devine. Robert Devine. But before we get there, we got to go all the way back to 2014, because for some reason, these documents were contained in the October 12th, 2022 FOIA dump to Dave Cullinane at Barstool Sports with regard to the death of Sandra Birchmore. Remember, it wouldn't be until, when was Farwell charged? Was it summer 2024? Summer 2020, I think it was summer 2024, when the feds got involved in the investigation. That is when charges were brought against Matthew Farwell. But because there are civil suits pending, we know that it wasn't just Matthew Farwell who was having relations with Sandra Birchmore. It was also his twin brother. It was also another guy named Joshua Heel who worked for like the animal control department or something. May have also been Robert Devine. It may have also been others. In fact, internal affairs reports were done involving, or investigations, Matthew Farwell, William Farwell, his twin, and Robert Devine. Despite all of those investigations, the Norfolk DA's office has never brought charges against Matthew Farwell for the murder of Sandra Birchmore. And right now, he's sitting in federal holding, awaiting, August of 2024. I remember it was summertime. Thanks, Em. Awaiting his murder trial in federal court. But federal murder charges are very hard to prove. This is a state murder case, slam dunk it could be. But a federal murder case is very hard to prove because you have to prove that she was going to go or did go and report Matthew Farwell for the crime of having relations with her when she was underage, and that she was a witness, and that he killed her because she was a witness. Do you see how that differs from a regular, not that there's any regular run-of-the-mill murder prosecutions, but a state murder prosecution? And it's a tough case to prove in federal court. I don't think that Officer Heel was an actual police officer. Wasn't he like an animal control officer or something, as I recall? Barbs. So it's harder, but I'm just saying it's a harder case to prove. They still haven't brought state murder charges. I don't think that they're going to, unless a new district attorney comes into town, like Adam Deitch. But let's go back. Let's go to page 66, because I want to go back first to 2014, because these records are included in the FOIA dump regarding the death of Sandra Birchmore. And I'm not sure if it was a mistake. I'm not sure if they pulled these because they did internal affairs investigations into Robert Devine. But a lot of you might not know about this. So we're pulling out the archives and we're getting into the lore. You want to talk about arrogance and entitlement? Take a look at Robert Devine. There we go. And this investigation started. Oops, let's go. November 12th of 2014. Fall of 2014. And this is a report, and the subject line is just Devine investigation. dated December 3rd of 2014, from Trooper Sean Quirk, who I don't know if he still is with the MSP. To Detective Lieutenant Kevin Shea, also was or is with the MSP. Devine is now an attorney because he lost his job as law enforcement. And so I guess he went to law school, passed the bar, and then in 2021, he became an attorney. And then he tried to get his job back. Matthew Farwell was not a federal employee. He was employed by Stoughton Police Department. And that's not federal. That's local. Oh, please. Let's not spread the misinformation. And let's read. Why didn't he get disbarred? Because this all happened before he ever became a lawyer. So how about we listen and we just go from here. If I keep getting distracted by questions in the chat, I'm never going to get there. On Wednesday, November 12, 2014, I, Trooper Sean Quirk, was assigned to investigate an alleged violation of a criminal harassment order. The harassment order, so that's, we know that they call that an HPO. We've heard a lot about that in the Aidan KEARNEY case. Remember, Jennifer McCabe tried to get one against Aidan KEARNEY, denied. Chris Albert tried to get one against Aidan KEARNEY, denied. This goes back to 2014. So there was a harassment order granted on October 3rd of 2014 by the Norfolk Superior Court against a woman, a girl, by the name of Tiffany Overstreet. The plaintiffs of the order are Robert and Lisa Devine, husband and wife. The order had an original expiration date of October 9th of 2014, but was extended through October 23rd of 2014. On October 20th of 2014, flowers were delivered to Lisa Devine at her residence. The message that accompanied the flowers stated, and then it's blank. It's redacted for like 3 or 4 lines. Robert Devine called it a nasty message when he testified in front of the Post Commission. Nasty and threatening are 2 different things. I don't know what it says because it's redacted. Here's what it also doesn't say. It also doesn't say in this initial report that Robert Devine is, I think, the acting deputy chief of the Stoughton Police Department. It does not say that his wife, Lisa Devine, is a police officer with the Quincy Police Department. Doesn't say that anywhere. You know how we talk about selective persecution of laws in Massachusetts? I mean, tell me if you think that this is another example of that. A couple of cops didn't like this woman. So they're prosecuting her because why? Because Robert Devine got caught cheating. Right. Steph says Devine and his wife set her up when he got caught cheating. They then ran her out of town. I have heard, I don't know if it's true, but I hope it's true, that Ms. Overstreet has like left and maybe changed her name, and that she maybe is like, does not want to be found, and good for her. Because this is what happens when people don't fight back or don't have the means to fight back, right? Karen Reed was very, 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 very lucky. An investigation revealed that the order was placed by blank. The order information came from the result of an administrative subpoena submitted to ftd.com by Officer Sandra Bennett. Remember the absurdity of the rubber duck investigation? Do you remember the 38 police report or 38-page police report resulting from Canton that came out of Canton PD about the little tiny rubber ducks, 1/10 the size of our queen, Lady Diana rubber duck, with little stickers that said Colin did it on the bottom, or IYKYK. Remember the 38-page police report that resulted from that? Wait till you hear what they did to investigate the flowers, okay? And tell me if you, as a citizen of Canton or Stoughton, if you went to the police and said, I got some creepy flowers with a nasty note, Can you send a subpoena to FTD to find out who sent them? You think they would do that for you? The order information came from the result of an administrative subpoena submitted to FTD.com by Officer Sandra Barrett. Robert Devine, I forgot, I don't even know what his title was at that time. Sergeant, I don't know. Advised that blank is a friend of Overstreet. Oh, so Tiffany's friend sent your wife flowers with a nasty note. Okay. Robert reported the incident to Stoughton Police, where Robert is the deputy chief. Oh, there it is. Deputy chief. Officer Sandra Bennett took the report, and Chief Sastani was made aware of the situation. Remember, this is all the way back in 2014, to think that they had the resources for this. On Saturday, November 15th, 2014, I spoke with Robert. He reported that the harassment order was sought because of ongoing harassment from Overstreet. Affidavit attached. He stated that since the order was granted, he's been receiving phone calls on his personal cell phone, number redacted, and emails from unknown numbers at all times of the day and night. Some of the calls and messages were reported to be threatening in nature. Robert advised that he searched the phone numbers and email addresses on the internet and found that most come back to a website called bandwidth.com. Robert provided me with a copy of the response he received from bandwidth.com's legal division. Bandwidth.com advised the numbers he requested were provided to a wholesale customer, Enflick Inc., and therefore legal service will need to be sent to that company. Enflick Inc. provides a free application called Text Now that allows a person to disguise their true number or email address. See, all this was going on all the way back in 2014. Text Now, bandwidth.com. Did you guys know about any of these resources? Robert also stated that the password for his Comcast account had been changed today, 11/15/14, but he had not requested a change. He stated that his inbox folder, sent folder, and contacts were all deleted. Oh, how convenient. How convenient. His inbox folder, his sent folder, and all of his contacts were deleted from his personal email. Do you think that's a coincidence? But he's going to blame Tiffany for this. Oh, please. Have these guys been deleting things for years? Same playbook. Same playbook. Is Text Now still a thing? He said he found 2 deleted emails in the trash bin of his account, right? Because whoever did that forgot to empty the trash. At this point, he then changed the username on his account. He further stated that there have been previous attempts to gain access to their accounts, Robert's Comcast accounts and somebody else's accounts, Robert's Yahoo's account, and Lisa's Pinterest account. Robert stated that no one has his passwords. I asked Robert that if Overstreet attempted to access his accounts, would she know the answers to his security passwords? And he stated, yes, probably. Really? How close was your month-long relationship with this woman that she would know the answers to your security questions? You guys have done the security questions before, right? Questions like, what was the model of your first car? Where did you meet your spouse? What was the name of your first boss? What elementary school did you go to? Did they have weeks and weeks and weeks of pillow talk? Proctor should have hired Devine to clear out his cloud, says Zoe. So I don't know if they meant answers to the security questions, mother's maiden name. Usually it's like weird stuff, like first pet's name, right? Like stuff like what's your favorite color? Who's your favorite band? Or are they referring to actual passwords? Either way, the fact that this woman would know them is a little bit interesting. Just a little. Unless he was trying to run her out of town, like somebody else said, in their opinion. On Sunday, November 16th, 2014, Robert contacted me to inform me that he received a message indicating that an email from his Comcast account failed to be delivered. He stated he had not tried to send a message. When he accessed his account, he found the message that was returned. He said it appeared to be from his account and was addressed to his cell phone number, redacted. The error message returned showing an IP address that uses AT&T as a service provider. And look at that, they got the IP address. Robert stated he uses Verizon as a service provider. There's an indication on the return receipt that the message may have come from www.textum.net. Textum.net. He also informed me that last night he received more texts from unknown numbers. A copy of the returned message is attached. On November 25th, 2014, I submitted a subpoena to AT&T. Really? Count them. Subpoena to FTD.com. A subpoena to AT&T. Why? Because the deputy chief of Stoughton PD claims that he got hacked and that his wife got flowers. Okay, let's keep going. On Monday, November 17th, 2014, at approximately 0700 hours, I went to Stoughton PD and met to meet with Robert. During our meeting, it doesn't say like Chief Devine, Robert. He doesn't say anything about formal introductions needed or anything like that. Right, they know how to subpoena a cell phone company. Isn't that wild? It's crazy. It's wild. Wait till you see, because it gets worse, Allie. It gets worse. At 7 a.m., he's going over there to Stoughton PD to meet with Robert. During our meeting, he spoke about his relationship with his wife and how he met Overstreet. He stated that last fall, okay, so that would have been the fall of 2013, so rewind a bit, he and his wife, Lisa, were considering separating. Keep that in mind, considering separating. Put a pin in that. Oh, thank you, Villanelle, for gifting 5 memberships. You're so sweet. You're a sweet pea. Thank you so much. Around this time, he became involved with Overstreet and things progressed into a more serious relationship. He advised that Overstreet's attitude toward him changed. She turned threatening and abusive. It's always the chicks, right? It's the bitches that'll get you. Right, Bobby? Robert stated that as the next summer approached, that would be summer 2013. No, last fall, that was 2013. The next summer would be summer 2014. He and his wife decided to reconcile their marriage. He wanted to end the relationship he had with Overstreet. He stated Overstreet wished to continue a relationship with him and did not want him to go back to his wife. She made threats of taking her own life if he abandoned her. YouTube doesn't like that word, so I'm just going to get out my red pen. Oh, see how this is already the game plan in 2014? She made threats of taking her own life if he abandoned her. Was his buddy Fanning? I mean, not Fanning. Was his buddy Farwell, who was an officer in the same department, Stoughton, in 2014? Is that where he got the idea? Just notice all of the similarities and the threads that are running through everything that we're covering and how far back they go. And this is only 12 years ago. From this time until the issuance of the order, there have been numerous instances of harassing text messages, some of which were threatening, and phone calls from unknown numbers. On Thursday, November 20th, 2014, Robert contacted me to inform me that his Google account password had been changed without his knowledge. He was able to provide a screenshot of the messages. And here's the message that says, your Google verification code is this. And it has that 1, 2. Password changed. And then your Google verification code is this. And we don't know what day it is because it just says today on the text message. So I guess we're going to assume that's Thursday, November 20th of 2014. Screenshots are good enough, right? He also informed me that some of his family friends received an email containing pictures of Overstreet and himself from the email account blank. Oh, what's that you say? Pornographic photos of you and the woman that you're now trying to run out of town, maybe? Huh. On November 25th of 2014, I sent an administrative subpoena to Google. Oh, you mean you can send subpoenas to Google too? Imagine that. Robert said that he plugged that name into Twitter and he found a Twitter page containing many pictures of a nude woman. Although the woman's head is not visible, Robert identified the woman as Overstreet. That's how well he knew her body. How long have they been passing around nudes? He stated the email address and Twitter, and then there's a whole bunch of stuff redacted. Maybe that's a nude, I'm not sure. He stated the email address and Twitter handle blank are not known to him. On November 21, 2014, I sent Twitter a preservation order for the preservation of the, it says consent, but I think what they mean is content. Wait a minute. So you can send Twitter preservation orders to preserve the entirety of a troll account? Oh, all the way back in 2014, that was possible? Does that mean you can still do it now? Oh, wow. I'm shooketh. A lot of people don't think that you can do that. But apparently they do that at the MSP. As of the date of this report, the page has been removed. That's convenient. On Wednesday, November 25th, 2014, Robert contacted me and informed me that another email was sent. He stated this email contained more pictures of he and Overstreet and was sent to coworkers and their spouses. Uh-oh. Sounds like revenge porn. He stated that some of the pictures were graphic and they came from Overstreet's email account that was allegedly accessed by an unknown individual. Oh, okay. So you don't even think that it was Tiffany who did this. You think somebody hacked into Tiffany's account and sent it from her email to all of your coworkers and their spouses, these pornographic pictures of you and the woman that you were stupid enough to take pictures of having sex with, that you were having an affair with. Okay, got it. Got it. I don't have ads during my live stream, so I don't know why you're getting any, Sherilyn. You shouldn't be. First of all, you're a member for over a year. And second of all, I don't play ads during my live streams, so that's weird. Unless you're just talking about other shows that you're watching. The email was reported to come from blank and blank, all redacted. And there's a whole other portion redacted, which I assume is a copy of an email or a copy of a pornographic picture. On December 2nd, 2014, Robert contacted me regarding information he received from Comcast, his internet service provider. Oh, so he could get his own information from Comcast. Comcast provided him with his account access logs and associated IP addresses. Oh, really? So your own provider, so your own email provider can provide you with the IP addresses of people who hack into your account? That's interesting. Yes. Yeah. Oh, this. Team Brittany says, stop taking photos of yourself, people. Yeah, just don't do it. Don't do it. Everyone needs YouTube Premium. You can get a student plan. You can get YouTube Lite. You can get discounted plans. And if you watch YouTube all day long, I'm telling you that it is 100% worth it. I can't recommend it enough. I haven't seen ads on YouTube since even before I had a channel on YouTube, because I always had YouTube Premium because I didn't want ads during the music videos that I was watching or the concerts that I was watching. Ads in the comments. I don't know what to tell you, but if we could possibly, I'm just going to turn the chat off because it's too distracting to me. I have self-diagnosed ADHD from Instagram. Be in Trouble 31 says, get YouTube Premium directly from YouTube, $15.99 a month. YouTube Lite is even less. A student plan is even less. So he sent just a letter. He sent just a letter to Comcast or an email, or he called them on the phone and said, send me all my logins from September 26th to November 15th of 2014 and the IP addresses that showed numerous bad password statuses, which could indicate that could indicate that someone tried to access his account. It could indicate that, or it could indicate that someone was trying to pretend that someone was trying to break into their account by just putting in the wrong password a whole lot of times. Okay. Some of the attempts were successful, which could indicate that someone actually accessed his account. And then it says there's a redaction there, which I guess is his email. Robert also received the same data for a second account, so he had a burner email too, which he changed to after he believed the first account was accessed on November 15th, 2014 through November 16th, 2014. On December 2nd of 2014, I sent an administrative subpoenas to Comcast and WDSPC because they are the service providers of the IP addresses that may have attempted to access the account. How many subpoenas are we up to now? Really? XOXO, Trooper Sean J. Quirk, MSP, assigned to the Norfolk DA's office. Yes, sir. Right away, sir. But wait, there's more. Because on December 17th, 2014, there's a report for, an arrest warrant for Tiffany Overstreet. From Trooper Sean Quirk to Lieutenant Kevin Shea. And boy, do they work quickly when it involves a sergeant at Stoughton PD. Can we stop talking about the ads in the YouTube Premium now? Does anybody have any interest in what I'm talking about at all? At all? Here's the arrest warrant for Tiffany Overstreet. On Wednesday, November 12th, 2014, I, Trooper Sean Quirk, was assigned to investigate an alleged violation of a criminal. So they're investigating a violation of the restraining order that Robert Devine and his wife, Quincy cop Lisa, had against this woman, Tiffany Overstreet, because Devine was caught having an affair with Tiffany Overstreet. So they got a restraining order against her, and now they're investigating an alleged violation of the order because they're alleging that she sent flowers to Lisa with a nasty note, and that she tried to hack into his accounts, and that somebody, he said it wasn't her though, sent corn of him and her to all of his troopers and their wives and all of the friends and everybody. And that should be a violation of the restraining order, because you know what they like to do. They like to selectively persecute the laws, and this is in 2014. So the original restraining order was granted October 3rd of 2014 by the Norfolk Superior Court against Tiffany Overstreet. The order had an original expiration date of October 9th of 2014, but was extended through October 23rd of 2014. On October 23rd of 2014, the order was continued until November 4th of 2014, but was later changed to November 13th of 2014. On November 14th, 2014, or actually 21014, whatever year that is in the future, all parties agreed to extend the harassment orders until January 15th of 2015. I don't know why. Probably because she had an opportunity to be heard. Maybe she couldn't afford an attorney, so they kept extending it. And then they both agreed, okay, let's just extend it to January of 2015. And then he repeats what we already know about the October 20th flowers that were delivered to the victim at her residence, but they don't say which victim, but was, you know, we use our context clues and it says her, so it's got to be Lisa Devine. Address was withheld in Stoughton. The message that accompanied the flowers stated blank. But of course, remember, they traced that back with their subpoena to FTD.com and they found out it wasn't Tiffany, it was a friend of Tiffany. Okay. Yep. An investigation revealed the order was placed by blank. The order came as a result of an administrative subpoena submitted to FTD.com by the Norfolk DA's office. The victim advised that blank is a friend of Overstreet. The person who sent the flowers is a friend of Overstreet. The victim reported the incident to the Stoughton police, where victim works. Okay, well, if we're talking about victim Devine, he works at Stoughton Police, but I don't think Lisa Devine worked at Stoughton Police at the time, did she? I don't think so. Maybe she did. You guys might know more than I do. Officer Sandra Barrett took the report and the chief was made aware of the situation. Okay, so the chief of Stoughton PD, because Devine was only the deputy chief, see? Pat Ray says, Overstreet's contrived charges were as revealing as what they did to Sandra. They intimidate and silence with false charges. And when that's not an option, they take the lives of their victims. So do we think that it was very lucky that Tiffany got away? Cupcakes petitioning for activity, gifted 5 memberships. You know why? Because she's amazing. Welcome to the 5 new members. I see you. It's random. I have nothing to do with it. No, I'm not talking about Tiffany working for the PD. She's not the victim here, Pat. The victim is Lisa Devine. Tiffany's the perp. Lisa Devine, as far as I know, was with Quincy PD. She was a police officer, or is, or was, or I don't know. I know we think of Tiffany as the victim here, but that's not who they're talking about. On Saturday, November 15th, 2014, because there's 2 victims here and they're not saying which is which. I spoke to the victim. He reported the harassment order was sought because of ongoing harassment from Overstreet. He said since the order was granted, he's been receiving phone calls on his personal cell phone, 781 blank, 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 and emails from unknown numbers at all times during the day and night. Well, how do you get an email from an unknown number? Maybe an unknown email address? Some of the calls and messages were reported to be threatening in nature. Okay, how come none of them are delineated here? How come you're not saying what the threats are? You know, to make her arrest a little bit more, I don't know, palatable. The victim advised that he searched the phone numbers and email addresses on the internet and found that most come back to a website called bandwidth.com. The victim provided me with a copy of the response he received from bandwidth.com's legal division. Bandwidth.com advised the numbers he requested were provided to a wholesale customer, Enflick Inc., and therefore legal service will need to be sent to that company. Enflick Inc. provides a free application called Text Now, which allows a person to disguise their true number or email address. One message came from blank, and a search of this email address shows that it came from Pinger Inc. Pinger Inc. is also a website that allows a person to disguise their email address. I mean, a lot of people know about this, right? This message appears to contain a screenshot of messages between Overstreet and a third party. Okay. It appeared that the third party sent the message from the above mentioned address to the victim. Okay. So tell me one thing Tiffany has done so far to actually deserve to be arrested. Where is even the probable cause here? Due to the anonymity of the third party and the potential violation of the harassment order, the Norfolk DA's office issued an administrative subpoena to Pinger. Then they talk about his password changes. If somebody allegedly tried to change his password and that his inbox folder, sent folder, and contacts were all deleted. Then he found those emails in the trash. And somebody tried to hack into his wife's Pinterest account. The victim stated no one else has his passwords. I asked the victim that if Overstreet attempted to access his accounts, would she know the answers to his security passwords? And he stated yes, probably. On Sunday, November 16th, and then it goes into all the same stuff. The undelivered email, the error message, AT&T, sending a subpoena to AT&T. How he went to Stoughton PD at 7 a.m. to meet with the victim. He didn't just say Robert this time, he said the victim. During our meeting, he spoke about his relationship with his wife and how he met Overstreet. He stated that in the fall of 2013, he and his wife were considering separating. Around this time, he became involved with Overstreet and things progressed into a more serious relationship. He advised that Overstreet's attitude toward him changed. She turned threatening and abusive. The victim stated that as the summer of 2014 approached, he and his wife decided to reconcile their marriage, and he wanted to end the relationship he had with Overstreet. He stated Overstreet wished to continue a relationship with him and did not want him to go back to his wife. She made threats of taking her own life if he abandoned her. From this time until the issuance of the order, there have been numerous instances of harassing text messages, some of which were threatening, and phone calls from unknown numbers. On Thursday, November 20th of 2014, the victim contacted me to inform me that his Google account password has been changed without his knowledge. He was able to provide a screenshot of the messages. He also informed me, this is right around Thanksgiving 2014. Happy Thanksgiving, everyone. He also informed me that some of his family friends received an email containing pictures of him and Tiffany you know, I guess pornographic in nature from this email account that is redacted. And so they sent a subpoena to Google right away, of course. And then he found a Twitter account, Twitter page containing many pictures of a nude woman. And even though her head wasn't visible, Devine said that he believed that that woman was Tiffany. So they sent a Twitter preservation order, and the page has been removed, or was removed. And then another email was sent November 25th, 2014. More pictures of him and Overstreet, and was sent to his coworkers and all their spouses. He stated some of the pictures were graphic, and they came from Tiffany's email account that was allegedly accessed by an unknown individual. So he doesn't even think Tiffany did it. He doesn't think she did it. So why are we arresting Tiffany again? I don't know. Let's keep reading. He provided me with a screen capture of the images, which I have reviewed. Oh, so he turned his own nudes over to the MSP. Cool. The email was reported to come from blank and blank. And then there's a footnote here, footnote 1, explaining what an IP address is. Computers on the internet identify each other by an internet protocol or IP address. IP addresses can assist law enforcement in finding a particular computer on the internet. IP addresses can typically lead the law enforcement officer to a particular internet service company, and that company can typically identify the account that used the IP address to access the internet. Wait, you mean they can get that information? That's so crazy. December 2nd, 2014. He forwards, Robert Devine forwards the information that Comcast sent him, which we just read. And so the Norfolk DA's office on December 2nd, right away, the same day that Devine contacts them, they subpoena Comcast and WD-SBC because that's the service providers of the IP addresses. December 4th, Pinger Inc. responded to the subpoena. And their customer support rep, whose name is Nadia Whiffen, provided account information for a certain username. The name on the account was blank. Well, I guess it wasn't Tiffany, because it wouldn't be redacted if it was Tiffany. This account was created on November 16th, 2014, and was only used that one day. What you mean? You mean trolls are out there creating sock accounts to troll people with, and they think they're not going to get caught? But Norfolk DA's office can send subpoenas to find out who they are? That's so crazy. There was no further activity on the account. He was also able to provide the IP address, begins in a 9 and ends in 18, for the computer that was used to create the account. I redacted that myself. A check of the IP address revealed it belonged to Comcast. And so what did they do right away? They subpoena Comcast. See, they know how to do an investigation into internet trolling, cyber crimes, internet harassment. Yeah, technology has apparently taken a huge step back since 2014, right, Erica? I know, it's so crazy. So crazy. And then right away, 4 days later, WDSPC responded to the subpoena issued on December 2nd. Okay, so maybe it was 6 days later. The help desk said they don't have any end user information because they lease IP addresses to several wireless companies. They informed us that the end user information that may exist would be provided by AT&T Wireless. So what did Norfolk DA's office do? They issued a subpoena to AT&T Wireless. Yeah, this is how they do it. So they know how to do it when it benefits them, or when they want to railroad a girl, maybe, and help each other out. Say no more. On Monday, December 8th, 2014, the Comcast Legal Rep Center responded to the administrative subpoena. The correspondence revealed that the subscriber for the IP address was, here's the IP address, and it was Tiffany Overstreet, and here's her address. The victim believed there had been previous attempts to access his Comcast accounts because he received all these notifications from Comcast. And here's the dates and times of all of those, starting in September of 2014 through November 2014. And the IP address was in there too. And it was the same IP address, which came back to Overstreet. And it was recorded by Comcast as making 4 successful attempts accessing victim's email account at Comcast.net. And here's all the attempts. 1, 2, 3, 4. Dates and times. On Tuesday, December 9th, 2014, while further reviewing the victim's email access log for his Comcast account, I observed the account was accessed November 15th, 2014. Well, that's some good police work. By someone with another IP address beginning with 7.3. The account access log showed 4 bad password attempts and then one successful attempt in less than 4 minutes. The last attempt, which was successful, came at 8:57 p.m. And at this time, the victim changed his email address to a different email address. According to the victim's Comcast account access log, a person using the same IP address, starting with 73, made 3 successful attempts. And so the victim provided me with a printout of an email that was sent from his new account at 8:54 p.m. He stated he did not send it. So somebody sent an email from his account. So what did the Norfolk DA's office do? They issued a subpoena to Comcast. And then they go on to talk about more IP addresses. Numerous instances during the time period in the account access log where a series of IP addresses tried to access the victim's account. And these were all IP addresses that were in sequential order, starting with 69, ending in 136 to 146. After a conversation with Lieutenant David McSweeney, he informed me that the series of IP addresses may indicate that the user was in a public place or at a business and the IP addresses were randomly assigned. The Norfolk DA's office issued a subpoena to Comcast. XOXO. Trooper Sean Quirk of the Massachusetts State Police, Norfolk County DA's office. But wait, there's more. There's more, you say? Yeah, there's more. On March 11th of 2015, at 1600 hours, Lieutenant David McSweeney, Attorney Kevin Mullen, and I, Trooper Sean Quirk, met at Attorney Timothy Burke's office in Needham. You know what's so crazy? Timothy Burke also represented Devine during those post-commission hearings. You know who else he represents? Fanning. He does. Represents Fanning. And many others, because I think he's a union lawyer. With Attorney Burke in Needham, their purpose of the meeting was to meet with Robert and Lisa Devine regarding their intentions going forward on the open case against Tiffany Overstreet. With Attorney Burke present, we met with Robert Devine and Lisa Devine separately. They both stated they no longer wanted to go forward with the case against Tiffany Overstreet and wanted to move forward with their lives. I showed the Devines pictures that were located on one of Overstreet's phones. I'm sorry, what? Oh, that's right, because they seized her phones. Where's the arrest report? I thought we were looking at the, the arrest report is next. But suffice to say, they're out of order. But he said, I showed the Devines pictures that were located on one of Overstreet's phones. These photos caused concern because one was taken at their daughter's school and others were Devine family pictures. Robert stated that the photo from the school was taken by his wife. Lisa confirmed same. I asked if they were concerned that the pictures were on her phone. They both thought her having them on her phone was creepy, but they were not concerned otherwise. Kristen Anderson said, Bob Devine was my boss. I worked for Stoughton PD. And you also went to Canton High, right? Didn't you tell me that earlier? There was always chatter in dispatch, she says. Kristen, change your name, please. Kristen, change your name. XOXO, Trooper Sean Quirk. But wait, let's look at Tiffany Overstreet's arrest report because they did actually arrest her. And he goes through the history, and we've been through the history many times. The flowers that were sent by her friend, apparently. All the subpoenas, all the ongoing harassment he was getting from unknown numbers and emails. All the subpoenas they sent out, all his passwords being changed, people trying to hack into his email, changing passwords. We've heard all this before. We've seen the screenshot. They sent the subpoena to Google, who owns Gmail. Uh-oh. He also informed me that some of his family and friends received an email containing pictures of Overstreet and himself from the email account jparks8889@gmail.com. We didn't see that email address before. On November 25th, a subpoena was sent to Google, who owns Gmail. Wait, you can find out someone who owns a Gmail address by sending a subpoena to Google? Who knew? Devine went through Twitter and found nudies on Twitter. I didn't know you could put nudies on Twitter. Can you? Was that a 2014 thing? Was that so 2014? Her head wasn't in him, but he knew they were her. And all the other stuff and things that Devine said and did, and all the subpoenas that they sent, and all the accessing of his accounts. And here we go. Look how fast they moved. On Wednesday, December 17th of 2014, I sought and received a search warrant from the Stoughton District Court to search for and seize computer systems and other storage media located at Tiffany Overstreet's address in Easton, Mass. Can you believe it? Of course you can. So the very next day, Thursday, December 18th of 2014 at 0700 hours, myself, Lieutenant David McSweeney, Sergeant Denise Darty, Trooper Sheila Kearney, related to Aidan, spelled the same way, and officers from the Easton Police Department executed the search warrant at Tiffany's house. After several attempts at knocking at the door, Tiffany did answer the door. We identified ourselves as police officers, and Overstreet was advised that we had a search warrant. Officers entered peacefully. Overstreet was given Miranda warnings by Lieutenant McSweeney and told that we were there as part of an investigation into Overstreet allegedly violating a harassment prevention order taken out by Robert and Lisa Devine. Overstreet stated that Robert called her just last night and has told her that he went to court and withdrew the HPO. I'm sorry, what? Tiffany told these guys and gals who were executing the search warrant that Robert just called her the night before to tell her that he went to court and withdrew the HPO.
Hello?
Hello. Hello, I'm here.
She said that he told her he loved her in that conversation. She said they have communicated back and forth with one another via phone and email over the past several weeks because he told her that he withdrew the order. What? These are official police reports, I'm reminding you. This is not gossip, rumor, speculation, nonsense. Thank you. Scott says, this is not Rumor Central. This is not Burger King. It's Melanie's right. If you don't like it, just leave only warning. And Team Brittany is very protective of families in the chat. So if you start talking about the families and where they live and what they're doing, it's not, we don't do that here. We don't do that here. There's other places for that. The point of this is that Devine has been communicating with her the whole time that she had a restraining order against them behind his wife's back. And then all of a sudden they just decide they're going to drop it in March. Interesting, right? She said that they have communicated back and forth with one another via phone and email over the past several weeks because he told her he withdrew the order. Overstreet then said that she did not want to talk to officers anymore. She was advised that she was being placed under arrest for the HPO violation. She was transported by an Easton PD marked cruiser to the Easton PD for booking and to await later transport to the Stoughton District Court. During the execution of the search warrant, after Overstreet was arrested and en route to the police department, Lieutenant McSweeney called Robert Devine to advise him of the arrest and search warrant execution. Lieutenant McSweeney explained to Robert that subpoenas had revealed that communications related to the ongoing harassment had come from Tiffany Overstreet's internet service at her address. According to Lieutenant McSweeney, Devine said that he was floored. He was floored that the activity was traced back to Overstreet. He was floored. He said he felt bamboozled as he thought that Overstreet was not the source of the harassment, but instead that someone was setting her up. I'm sorry, what? Then why have you been at the police department and at your lawyer's office every day with all this information trying to get Tiffany Overstreet arrested for violating the restraining order if you didn't even think it was her, that you thought she was being set up? What? He was floored? Yes, exactly, Heather. He was still in a relationship with her while accusing her of harassing him. Exactly. Yes, we do. It's been the same guy all along who wrote this. But I forget his name right now. Sean Quirk. Sean Quirk. I'll read that again. According to Lieutenant McSweeney, Devine said he was floored that the activity was traced back to Overstreet. He said he felt bamboozled as he thought that Overstreet was not the source of the harassment, but instead that someone was setting her up. He thought that eventually records would reveal some other suspect and that Overstreet would be seen as the victim as well. He admitted that he had been having contact with Overstreet over the past several weeks while the HPO was in effect, and that he did initiate some of the contact, including meeting for dinner at one point to discuss the related incidents. I'm sorry, what? He again said that he continued to communicate with Overstreet because he felt she was not the source of the harassment. Lieutenant McSweeney said that he reminded Robert that he took out the HPO against Overstreet and that he, Robert, was initiating much of the communication between him and Overstreet. Robert repeated that Overstreet had him fooled and bamboozled him. During the search warrant, some digital communications located on a cell phone identified by Overstreet as belonging to her were viewed. One message was from the username blank. This username is associated with some of the harassing anonymous communications related to this investigation. Okay, so it wasn't her. Officers completed the search warrant execution, seizing several computer devices and cell phones. Oh, really? So they took all her computers, all her cell phones. All seized items will be returned to the Norfolk DA's office pending further analysis. Yep. Thank you, Mike. He took out the HPO to appease his wife, in my view. Of course he did. Of course he did. And then he had to look like he really, really, really wanted her to be prosecuted, right? He really, really wanted her to be prosecuted. And then he says he was bamboozled. Really? Even after all those pornographic pictures were sent to all your friends and family, you still want to try and make it work? Give Stand By Your Man a whole new meaning. On December 18th, 2014, at approximately 0900 hours, while at the Easton Police Department, Overstreet initiated contact with officers and stated that she would like to speak with the officers. After going over Miranda warnings again, Sergeant Darty and I spoke with Overstreet. The interview was video and audio recorded. What? 2014, the Massachusetts State Police had the ability to video and audio record a witness interview? The entire interview has been memorialized on a DVD. The following came out from our conversation with Overstreet. During the interview, Overstreet admitted that she continued to have a physical relationship with Robert since the harassment order was issued. Physical relationship. She stated they continuously text and email each other. She stated that Robert is usually the one who initiates the contact. She denied any knowledge of spoofing, creating accounts on spoofing websites, sending emails, texts, etc. from same. XOXO, Trooper Sean Quirk, MSP, Norfolk DA's office. So she was arrested in December of 2014. And then the report before this, because it's out of order, of course, was in March of 2015 when Devine and his wife said, we're just going to drop it. We don't want to go after her. We don't want to have her prosecuted because we just want to try and we're going to just try and work it out. Oh, Team Brittany gifted 5 memberships. Thank you, Team Brittany. One of the most amazing moderators on this channel. Do you think that Robert was the one who sent Tiffany the pictures from the daughter's school and family pictures? Do you think that maybe Robert was the one who sent those to Tiffany and that's why they were on her phone? And then they both thought her having them on her phone was creepy, but they weren't concerned otherwise. How is this not a book or miniseries? Wait, just wait. So that brings us to March of 2015. Steph says he totally set her up. March of 2015. Now, here is a (2014) Facebook post. Because we like to connect all the dots. Pins it on the girl, right? Pins it on the girl. Oh, well, that's funny because now that post is not there anymore. It's a 2014 post with a picture of Fanning representing the MSP at some, oh, here it is. All right, here we go. All right, October 15th, 2014. Take this down, put this up. Everything's related. 6 degrees of separation. Here's Fanning. And this is posted by Fanning is on the left. October 15th of 2014. Today, Boston Fox 25 invited the state police to their studio to talk to Melissa Mahan about identifying and prosecution of drug driving. Trooper John Fanning, representing the state police. Here's some images from this morning. And then there he is. He was there in 2014 too. And who else was? Proctor. Tiffany was of age, but I'm not sure how old, but I'm going to tell you right now. So hang on. When did he drop the charges about her, against her? Oh, that's right. March of 2015. Here's an article from the Enterprise from January 14th of 2015. Stoughton deputy police chief linked to sex scandal. Stoughton deputy police chief Robert Devine and Tiffany Overstreet. I think that Tiffany Overstreet has gotten the duck out of there. Maybe changed her name. That's what I heard. So I don't know for sure, but I hope she did. Here's the article from January talking about the sex scandal. The duties for Stoughton Deputy Police Chief Robert Devine have been altered after an extramarital affair resulted in graphic photos of him and his alleged mistress being sent to police. The arrest of an Easton woman and an ongoing state police investigation, court records show. Stoughton Police Chief Paul Shastani said Tuesday that modifications have been made regarding the role of the 42-year-old Devine, who told state police that he had a months-long affair with Tiffany Overstreet, 30, so she was 30 at the time, somebody asked, of Easton that went sour, according to court records. Devine is second in command in Stoughton and acting chief when Shastani is away. Good, I'm glad about that stuff. Overstreet was arrested December 18th by state police and charged with 3 counts of violating HPOs taken out against her by Devine and his wife in October. Overstreet was arraigned in Stoughton District Court and released on personal recognizance. The case has been transferred to Dedham District Court. The matter has led Shastani to take on some of Devine's work and prompted at least one police expert to question whether Devine should stay in his position. But Shastani stood by the deputy chief, saying Devine is the victim in this case and terming the situation a personal matter. Oh, that's so interesting. Because 2 months later, Devine would drop all the charges. He is ensured due process, said Shastani. He is a victim, and when the case finds its way to court, the truth and all the information that is circulating will come out. And what will happen is there will be an assessment like everything we'll assess as we move downstream. Oh, okay, cool. Devine emerged as a leader in the department in the wake of an FBI corruption probe. Wait, what? That resulted in the convictions of several Stoughton officers in 2010. Oh, how interesting. So Devine emerges as a leader after an FBI corruption probe into Stoughton PD, which ended in 2010, resulted in the convictions of several Stoughton police officers. You see why the lore is so important here? L-O-R-E, not L-U-R-E, but L-O-R-E. Devine had also been the department spokesman and has worked as an instructor in the FBI's Law Enforcement Executive Development Association program. It doesn't mention here him running the Police Explorers program with children. Shastani said Devine, who made $122,695 in 2014, will step back from his spokesman duties while the investigation, which has involved the Norfolk County DA's office, continues. News at 11. But wait, there's more. Wicked Local. This was, so this was in, when did I say this was in January of 2015? January 14th of 2015. And then wickedlocal.com reports in April of 2015, case dropped against Easton woman involved with Stoughton deputy police chief. Charges have been dropped against an Easton woman who was accused of violating HPOs taken out by the deputy police chief. Tiffany Overstreet, 30, was charged with 3 counts of violating the HPO taken out by Stoughton deputy police chief Robert Devine and his wife. Devine told state police he had a months-long affair with Overstreet that went sour, court documents show. The government entered a nolle pros, means they're not going to prosecute, said Kevin Mullen, the special prosecutor appointed to the case by the Norfolk DA's office. Oh, look, Norfolk DA's office, where they've been using special prosecutors since at least 2014. It's my decision after consulting with the victims on the case. We thought it was best for all parties. The victims wanted the case to come to an end. Right. How many months long was the affair? A harassment prevention order was taken out by Devine against Overstreet was dropped in mid-January when the deputy police chief failed to appear in Norfolk Superior Court for a January 15th hearing to extend the order. Court documents show. Oh, so he just didn't show up. You know why? Because he was still having an affair with her. The charges are dropped. Mullen says the case against Miss Overstreet is over. Devine and Overstreet could not immediately be reached for comment on Tuesday afternoon. Jake Creedon, Overstreet's attorney, said a nolle pros doesn't allow the judge to make a ruling on the case. I think it's a wonderful decision, Creedon said. It's a private matter. The decision came at a pretrial hearing for Overstreet in Dedham District Court on Tuesday morning. Oops. See what you guys have to say about this. Oh, we're just getting started. This is just the beginning. Kim said, Grant is a smart man. Great interview by Justice Served. Thanks, Kim, for being here for 6 months. Lauren said, I saw Dave Matthews last night, hung with Carter backstage, watched the show from the pit. Set list was incredible. I can die happy now. I wish you'd been there. I do too. The set list was fire. Wish you'd been there. Love you. Oops, thanks, Rolly. I wish I'd been there too. I was saying that last night as I was sitting here, right here in my chair. I said, I wish right now I was in Guilford, New Hampshire, in the pit, watching Dave Matthews with Lauren. Oh, please. Stone opener, really? Oh, it's all right. I'm going to see him next week. You're welcome. Thanks for all I do. You're welcome. Oh, please. So damn lucky, Lauren. So damn lucky. Welcome, Shelby. Welcome, ZBDDD. And Jane said, when they want to railroad a girl. I said that. In my opinion, that's what was happening here. Thanks for being here for a month. Gildays Gilead. Oh, so well done. Hold on. Let's put up the Handmaid's Tale rubber duck for that one. There it is. Shaking my head. Such long-term corruption. I imagine there's much more to be discovered. People think it's so crazy that this could never happen. Like, they would never do this. They would never cover for each other. It's just impossible. There'd have to be so many people involved in a cover-up. No, just some people who, you know, have each other's backs, maybe, that have been working together for a decade or so. Archie said, I would bet he did all that himself. Thanks, Archie, for your 10. I would bet. You could be right. Oh, look at Bessie gifting 10 memberships. You guys are so generous tonight. I love you with all of my heart. I love you so much. Thanks, Bats. Kelly said, so Devine changed his email address and she tried to access it. How did she know he changed it and to what? Police just blindly believing police again. Well, and plus she's sleeping with him the whole entire time. Why would she be trying to sabotage him behind the scenes? It doesn't make any sense. He doesn't make any sense because Archie says he did all of this to save his marriage. Poor girl. Thanks, Kelly and Archie. And Gigi's here. She's already engraving the silver clinks. She says, I'm late. Working on our pool. Okay, I'm watching my husband work on the pool. Just wanted to stop in and say hi. Melmaz chat. Miss all you. Back full time on Monday. Love you, Velmar. We love you, Gigi. We miss you, and we hope your shoulder is getting better. All right. So that brings us to 2015. Here's something that happens in 2017. Hold on for a second while I get here. No, I'm sorry. March of 2015. March of 2015. So, okay, this makes more sense now. So in March of 2015, that's when he drops the charges. Yeah? Right. And then, was it March? He decided in March, right? We read a police report. It was March. Guess what happens in March of 2015? Do you remember what happened in Quincy at the Home Ice Sports Bar in March of 2015? I know you do. The murder of Keith Boudreau. The murder of Keith Boudreau happens in March of 2015. Hold on. Pull up some original articles. Do you remember? Paul Fahey is convicted of the murder of Keith Boudreau. Punched him twice and it killed him. Sucker punched him twice. It killed him. There were allegations that after he sucker punched him twice, he stomped on his head, and then the owner of the bar helped him drag his body out into the alleyway. And Paul Fahey was convicted. Yep. Fanning and Crawford were involved. Yep. You remember. He was convicted (2017). Here's an original CBS Boston News report of the day of his conviction. But remember, all this is going on at the same time. Fanning and Crawford went to the bar the Home Ice Sports Bar in Quincy and took the entire surveillance system out, and it gets worse from there. But so hang on a second. Let's go here. This is a news piece about his conviction in 2017. Here you go.
An emotional day in court where a man convicted in a deadly bar beating was sentenced for murder.
The victim's family delivered a message for the killer. WBZ's Nick Giovanni is live in Quincy with more on this. Nick?
Kate and Chris, I can tell you here outside the courthouse this morning, the victim's mother was telling us, described this as a case that...
Look at where they are, outside Norfolk Superior Court. Can you believe it?
It could have happened to anyone. You go out for a few beers, next thing you know, a bully comes up and takes your life, as she put it. But today, she felt justice was served. 44-year-old Paul Fahey of Quincy stood before a judge inside Norfolk Superior Court Thursday morning to be sentenced for second-degree murder, convicted of killing Keith Boudreau at a sports bar back in 2015.
The jury understood exactly what people were saying. And
oh, there's Michael Marcy. There's Michael Marcy speaking out after the conviction. Because there was video. But wait, there's more.
Sports bar back in 2015.
The jury understood exactly what people were saying and came back in less than 2 hours. It was, to us, that was kind of remarkable.
Calling Fahey a cowardly bully. Prosecutors say he was unprovoked when he punched Boudreau, a father of two, in the face, then stomped on his head inside the Home Ice sports bar.
I miss my son more than anyone could ever imagine, but I find great strength in knowing that he was a decent man.
Before Fahey was sentenced to life in prison, members of Boudreau's family addressed the court for victim impact statements, starting with his mother, who first paid tribute to the son she lost.
I used to say to Keith, "Be careful out there, Keith." And he always said to me, "Mom, I don't make enemies, I make friends."
The kind of person who has literally taken his shirt off of his own back to give to someone else.
Then the family turned their attention to Fahey.
The damage you have caused to his two young boys is unspeakable. I hope that night plays out in his mind over and over and over and haunts him for the rest of his life the way it does to us.
Mr. Fahey, in closing, God forgives, I don't.
And Fahey showed little emotion in the courtroom until his attorney read a letter from his son to the judge telling him that Fahey was always there for him as a father. He's now sentenced to life in prison, eligible to apply for parole in 15 years. We're live in Dedham. Nick Giovanni, WBZ News.
But here's what happened. Despite the fact that Paul Fahey was convicted in 2017 and sentenced to life, went up to the appellate court, and he was awarded a new trial. He got a new trial. He got a new trial. It was interesting that that reporter used the word bully in his piece because he got a new trial because the prosecutor for the Norfolk DA's office, whose name was Craig Kowalski, used such inflammatory language throughout the trial and during his closing. I think he called him a bully something like 13 times, that the appellate court said it was an unfair trial. He gets a new trial. He got out. Is he out? I couldn't find out if he was retried. A new trial was ordered for him in 2021. So put a pin in that. He gets convicted in 2017. Okay, wait, because I gotta like kind of do this in order. And of course, after his conviction, there's a lawsuit, right? There's a wrongful death lawsuit brought by the family of Keith Boudreau against Paul Fahey and some other defendants, okay, for wrongful death. I found this like falling into a rabbit hole last year, or however many years ago it was that we started covering this. During the civil suit, Paul Fahey is representing himself. Okay, at this point, he's still in jail. This is in March of 2020. And he's trying to represent himself against the wrongful death case. Is he not out of jail? Are you saying don't listen to me? Did you say he was out of jail like you were making a joke? I don't know. That's why I can't look at the chat. He's trying to defend himself in the wrongful death case that's brought against him. And so he brings a motion in the civil case of the estate of Keith Boudreau against Paul Fahey. And listen to this motion. It's short. This is defendant Paul Fahey's motion for an order to the Norfolk DA's office to produce to Fahey all unedited documentary and video records in their possession in the matter of events occurring at the Home Ice Sports Bar in Quincy on March 23rd, 2015. Okay? 7 days. 7 days after Devine drops the case against Tiffany Overstreet. This happens in Quincy. And remember, his wife is a Quincy police officer, Lisa. I don't even know if that's related at all in any way, shape, or form. No, Joe Kowalski. That's Joe Kowalski. This is Kowalski, totally different. Pro se defendant Paul Fahey respectfully requests that this honorable court allow this motion and order the Norfolk DA's office to produce to him all unedited documentary and video records in their possession in the matter of events occurring at the Home Ice Sports Bar on March 23rd of 2015 as grounds. This honorable court allowed a similar motion for an order directed at the Quincy Police Department on February 12th of 2020. The Quincy PD followed the order, but was only able to produce limited records. Apparently, the Norfolk DA's office received the bulk of the unedited video surveillance transported there by Trooper Fanning and Coleen Crawford, as Exhibit A shows. 2015. Remember, we've seen the corporate documents. Trooper Fanning and Coleen Crawford have had several video editing companies together. The final one was dissolved on the day that Karen Reed was brought into court, February 2nd of 2022. These records have paramount relevancy to factual determinations in this civil action. Though Fahey was at one time provided with surveillance by the DA's office regarding a criminal investigation into events occurring on March 23rd of 2015 at the Home Ice Sports Bar, these videos and documents were heavily edited by the sure hand of counsel for the district attorney's office. I'm sorry, what? This means that the records were curated rather than raw, generating questions of accuracy. But in the civil session, where the district attorney's office is not a party, it is contrary to the truth-seeking character of the superior court to limit the record to evidence the district attorney's office finds relevant. That is, the complete record must be produced unedited and raw. This will benefit the fair adjudication of this case. Finally, Fahey notes that the other parties to this action assented to the previous motion for an order directed at the Quincy Police Department. No tampering, LOL. There's no reason to believe they will contest this motion. Fahey attaches a proposed order. Paul Fahey, pro se, March 15th, 2020. Okay. Here's Exhibit A. This is the police report from the Quincy bar fight. Here it is. This is the supplemental report. This is not the original police report of the killing or the death. This is supplemental. March 29th of 2015. Your mind has started to wander. Come on back. On Friday, March 27th, 2015, at approximately 3:50 p.m., Detective Tom Pepjovnik, Pepjonovic, I don't know how to pronounce that. Pepjonovic. I'm not even going to try. And I, Detective P. Pacino, because of course there's got to be a Pacino in here. It's not Al, but still. Along with Trooper John Fanning and Coleen Crawford. It says Trooper John Fanning is MSP, CPAC, and Coleen Crawford, Norfolk County Multimedia Director, Forensic Video Analyst, traveled to the Home Ice Sports Bar at 35 Washington Street to retrieve surveillance video pertaining to the incident that occurred on Monday, March 23rd of 2015. I couldn't find anything on a retrial either, Carrie. I don't know if he's still in custody. I don't know what's going on. Upon arrival at the Home Ice Sports Bar, we had the opportunity to meet with Gerard DeLuca, the owner. We advised DeLuca as to the reason for our visit, and he accompanied us downstairs to his office where the surveillance system is located. Detective Pep Janovic presented Mr. DeLuca with a Quincy Police Department consent for search form, which was subsequently signed and dated by Mr. DeLuca. I don't know why DeLuca did that, because allegedly DeLuca is the one who helped drag him out to the alley, Keith Boudreau. After obtaining verbal and written consent from Mr. DeLuca, Coleen Crawford attempted to download the surveillance video of the incident. Due to the age of the surveillance video system, Coleen Crawford was unable to retrieve the surveillance video. It was determined that Coleen Crawford would need to secure their surveillance video system as evidence and perform forensic video analysis at the Norfolk County DA's office in Canton, Mass. What? They took the whole system. At this point, the surveillance video system was secured as evidence and transported by Trooper Fanning and Coleen Crawford to the Norfolk DA's office in Canton, Mass. You don't say. The completed Quincy Police Department consent for search form was submitted to the detective AJ Carthus. Respectfully submitted, XOXO Detective David Pacino. Pacino and Steele. Looks like they're with Quincy PD. They took the whole system. But wait. He's claiming that it was altered. Yeah, they took the whole system. Isn't that crazy? But wait. There's always more. In 2021, Paul Fahey got a new trial. According to Boston.com, if anybody feels like going down a rabbit hole, see if you can find out if Paul Fahey is still in custody, if he ever got a new trial. I can't find anything about it. And this article is from March 16th, 2021. Why the man convicted in a fatal Quincy bar attack is getting a new trial. A fatal 2015 Quincy bar attack is getting a new trial. Paul Fahey was convicted of second-degree murder in 2017 for allegedly punching and stomping on the head of Keith Boudreau in the now-closed Home Ice Sports Bar in March of 2015. There he is. The Massachusetts Appeals Court, citing improper conduct by the prosecution, granted a new trial to a man convicted of killing another man in an unprovoked attack in a Quincy bar. Paul Fahey was convicted of second-degree murder in 2017 for allegedly punching and stomping on the head of Keith Boudreau in the now-closed Home Ice Sports Bar in March of 2015. Boudreau, 42, died days later at the hospital. And that is tragic, horrific. Tragic, horrific, never should have happened. But exactly. JP says, sorry, if you want my entire system, get an effing warrant. I don't care if I have nothing to hide, but you aren't getting my entire bar's surveillance system. Yep. The court, in its decision Monday, called the prosecutor's missteps pervasive and in many instances egregious. We agree with the defendant that a new trial is warranted based on the cumulative effect of the prosecutor's improper cross-examination and inflammatory closing argument, the Associate Justice James Milkey said in the decision. The prosecutor called Fahey a bully 13 times during closing arguments. The court said it is improper for a prosecutor to use insulting names designed to evoke an emotional rather than a rational response from jurors. Fahey's lawyer, Barbara Monroe, praised the decision. The prosecutor's conduct was pretty egregious, and the appeals court agreed. The Norfolk DA's office plans to retry the case. We recognize that errors were made, as the court pointed out. The district attorney's statement said, "We are disappointed for the family. Manti Cupcake said he had a new trial in 2024 and was convicted for manslaughter. If you can like email me the receipt on that, I would love that so much. Fanbase at mlittlelaw.com. Thank you. My little deep shallow dive this afternoon didn't find that. Notice here they do not name the prosecutor. I'm going to tell you his name. His name's Craig Kowalski. He's now in private practice. And he was publicly reprimanded in 2024 by the Bar Association in Massachusetts. Uh-huh. Allie went to the MassGov prisoner website and there's no results on Paul Fahey. Well, that's interesting. Jim's sister says, we literally live in the Salem witch trials here. It is frightening. But wait, there's more. It needs to be a shirt. I don't know. He was convicted of involuntary manslaughter. Nobody could find him in the inmate lookup. So is he out? This was 2015. Could be. And BB said, imagine if we set up a fund and did a FOIA request on every one of them. I think all of our heads would pop off in different directions. Love you, Mel. I love you too, Aunt BB. Thanks for your 10. Babe's mom just says, happy Thursday. Happy Thursday. Thank you for your 10. Pima Bo says, such a well-woven presentation today. I appreciate you. Oh, thank you. I appreciate you too. But wait, there's more. Here's the decision. Oops. From the appellate court. So I guess Superior Court is the lowest court. Then it's the appellate court, and then it's the SJC, right? So it didn't go all the way up to the SJC. It went to the mid-level appellate court. I mean, how many trials did the Norfolk DA's office have to F up before they clean house? It's a great point. It's a great point. He was convicted of involuntary manslaughter on the retrial. So do we think he's out? What was he sentenced to? Mm-hmm. How many times can they screw it up? Pre-retrial imprisonment, because he had been incarcerated continuously since his initial arrest in March of 2015, covering both his original 2017 trial and the interim period when, ... So I guess he was released. He was sentenced to life in prison. Isn't that the news piece that we watched originally? And Michael Marcy was so proud of himself that he dislocated his shoulder, patting himself on the back. All right, I need receipts before I can report on that for sure. But here are the gruesome details of the actual event. Because they're in the appellate court's decision to give him a new trial. And this was the this was decided on March 15th, 2021. Yes, Boudreau's injury sounded exactly like John O'Keefe's. That's why I'm reading this to you. Thank you for calling me back to remind me where I'm going with this. All right, here you go. Let's move it over there. Move me over here. The defendant and the victim, Keith Boudreau, did not know each other. By happenstance, they were both at the home ice sports bar in the city of Quincy on the night of March 23rd of 2015. There, the defendant punched Boudreau in the head, causing him to fall to the bar's tiled floor. The defendant then stomped on Boudreau while he was lying on the floor, and 11 days later, Boudreau died of a head injury. Horrific, horrific, horrific. The defendant was indicted for murder in the first degree, and a superior court jury found him guilty of murder in the second degree. On appeal, he argues, among other things, that the evidence was sufficient to convict him only of manslaughter, not murder. We disagree. However, we agree with the defendant that a new trial is warranted based on the cumulative effect of the prosecutor's improper cross-examination and inflammatory closing argument. We therefore vacate the conviction. And remember, this was in Norfolk Superior Court. Background. We summarize the trial testimony and other evidence, reserving certain details for later discussion. At 2 p.m. on the date in question, Boudreau was at a bar around the corner from home ice celebrating his fiance's birthday. At one point, his fiance's brother, Eric Manley, while seated in his wheelchair, hit Boudreau by either slapping him in the jaw or punching him in the nose. Eventually, Boudreau was escorted out of the bar, and he and his fiance went to home ice. While drinking at home ice, Boudreau began arguing with his fiancée to the point that they were asked to leave that bar as well. The defendant and his girlfriend were present when Boudreau was asked to leave, but they did not interact with him. Yeah, everybody hit the like button. A half hour or so later, Boudreau came back to home ice alone. At that time, the defendant and his girlfriend were seated at the bar counter drinking beer. Boudreau, who was exhibiting signs of intoxication, stood directly over the defendant's shoulder, asking if anyone had seen his fiancée. Have you seen my fiancée? 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 It's a Seinfeld reference. There was evidence that Boudreau was staring at the defendant or the defendant's girlfriend, either directly or as reflected in the mirror behind the bar counter. The defendant then, seemingly out of the blue, punched Boudreau in the side of the head, causing him to fall and to hit his head on the tiled floor. At this point, the bartender heard the defendant say something about Boudreau staring at him and that he was sick of the junkies in Quincy. Note 1. I don't know where the notes might be all the way at the end. We'll get there later. The defendant approached the now prone Boudreau and stomped once with his foot. It was uncontested that at the time, the defendant weighed well more than 200 pounds and was wearing heavy work boots that had a patterned sole. One witness, home ice's owner, Gerard DeLuca, the guy who gave up his surveillance system, testified that he saw the boot come down on the side of Boudreau's head. Oh. Change your testimony, DeLuca. Give us your surveillance system and we'll keep you out of it. The other witnesses saw the defendant stomp, but they did not see what part of Boudreau's body, if any, was hit. The witnesses at the scene described the sound the boot made when it came down as a thud or a crack. According to DeLuca, after the incident, the defendant told him not to call 911 and to keep his mouth shut. DeLuca then helped the defendant drag Boudreau's unconscious body through home ice's kitchen to a rear parking area. At some point, Boudreau vomited, but he otherwise was motionless. I'm sorry, what? Remember there was vomit found in John O'Keefe's boxer shorts? We're going to find out that the only evidence, that there's really no evidence that he stomped on his head and that he was likely killed by that one punch. By the one punch, and then he fell back, and at one point, he vomited. The defendant splashed some water on Boudreau's face, but Boudreau did not regain consciousness. The defendant then left home ice, but he paused just outside the bar to speak with another bar patron and a passing friend, Patrick Dugan. Dugan testified that during this conversation, the defendant acted out what just had occurred inside home ice and admitted that he both punched a guy staring at him and stepped on him. The interaction among the defendant, Dugan, and the third person was also captured on a video surveillance camera, albeit without sound. I'm sorry, does this have to do with the altered video? Does the video surveillance camera usually have sound? And then just in this case, it didn't have sound? The video recording corroborated Dugan's testimony by showing that the defendant at one point using his left fist to reenact the punch that had felled Boudreau. Moreover, as the defendant was leaving the conversation to get into a car, he can be seen apparently stomping his foot on the ground. The defendant ultimately left and stopped at another bar and had a quick drink to calm his nerves. After the defendant left home ice, DeLuca called 911. He reported that Boudreau was intoxicated and did not say anything about the altercation. Really? So there's a dead guy that you dragged out to the parking lot with the guy who sucker punched him, and you call 911 and just say there's a drunk guy in the parking lot. Okay, there's a guy passed out in the parking lot. Is that what you said? Paramedics took Boudreau to a local emergency room in Quincy. The attending nurse observed that Boudreau appeared to be intoxicated. She did not see, he did not die yet. He died like 11 days later. The attending nurse observed that Boudreau appeared to be intoxicated. She did not see external signs of trauma to Boudreau's head other than some dried blood around his nostrils. What? So there's no evidence that this man stepped on his head, stomped on his head with steel toe boots with a pattern on the bottom of them? Okay. I guess he didn't even have a gash on his head. Why didn't the nurse or first responders automatically think that he was hit by a car? You mean you didn't think this was a pedestrian accident? However, when Boudreau's condition did not improve after about 1.5 hours, the nurse suspected that Boudreau had suffered a serious head injury. A computer-assisted tomography CAT scan revealed bleeding inside his head. Boudreau was then transferred to Massachusetts General, where surgery was performed. Boudreau died 11 days later. Oh, he probably had both shoes on. That's right, Zoe. That's why. A medical examiner, Dr. Robert Welton, conducted the autopsy and opined that the cause of death was blunt force injury of the head. He explained that the fatal head injury could have been caused by a punch to the head by somebody striking a hard surface on the floor or by a boot. Really? Who strong-armed Welton into saying by a boot? "26 meh knows," says when somebody gets boot stomped, the prints are always there. The medical examiner also testified that it was unlikely that the injury was caused by a slap to Boudreau's jaw. When he examined Boudreau's body, the medical examiner did not see any visible external injuries on his head, including any bruising, scraping, or swelling, with the exception of around the incision from the surgery. When asked on cross-examination, if someone were to stomp on someone's head with a heavy work boot with a pattern, it's likely that there could be some visible external injuries, correct? The medical examiner answered, potentially yes. On redirect examination, he subsequently added that a boot that came down on someone's head without any lateral movement would not always leave external injuries. The medical examiner did mention, albeit in passing, that there was some contusions on the torso of Boudreau's body. The defendant testified on his own behalf. Wow, that's interesting. Paul Fahey took the stand and admitted that he punched Boudreau on the right side of Boudreau's face with his left hand. Oh, so he's a lefty? Remember the egg over John O'Keefe's right eye? Do you remember the egg? I do. I remember the egg. He denied that he stomped on Boudreau's head. The defendant claimed that he made a split-second decision to punch Boudreau out of fear that Boudreau was about to attack him. He described how Boudreau, who had been staring at him and had one hand in his pocket, made a sudden movement toward him. There was no evidence to corroborate the defendant's claim that Boudreau had made a sudden movement toward him, and ultimately the jury found that the defendant had not acted in self-defense and convicted him of murder in the second degree. The jury acquitted the defendant of a witness intimidation charge based on his comments to DeLuca. Okay, so then they're talking about the sufficiency of the evidence, and they get into a whole bunch of law here. He's saying the injury could happen another way from that other guy who slapped him in the jaw earlier at the other bar. But the appellate court found that there was enough evidence to convict him, but it was because of the actions of the prosecutor that he deserved a new trial. But I want to see what they say about the video, because that's what I'm really interested in here. Next, the defendant argues that the evidence was insufficient because it was not definitively established whether Boudreau's death was caused by the defendant punching his head, either by the punch itself or by Boudreau's hitting his head on the floor as a result of the punch, or instead by the defendant subsequently stomping on Boudreau's head with a heavy work boot. The defendant argues that if it was the punch that killed Boudreau, then as a matter of law, this could not support a finding that he, the defendant, acted with the requisite malice because of the inherent unlikelihood that a single punch would kill an otherwise healthy person. A single punch. And then here's what the appellate court says. We are skeptical about the defendant's premise that as a matter of law, a jury could not find beyond a reasonable doubt that a defendant who killed someone with a single punch had acted with malice. We need not resolve that issue here, however, because the evidence of injury did not consist solely of a single punch. Do you think somebody could be killed by a single punch? And Be in Trouble says maybe this is what the McCabe's and Alberts were scared of, in my opinion. Interesting, right? Here's another case finding that a sucker punch of particularly vulnerable victim was committed with conscious disregard for life. The appellate court says, in short, there was ample evidence for the jury to find that Boudreau died as a direct result of two blows that the defendant inflicted in short succession and with malice. Nothing more was required. And then they go on to talk about the misconduct of the prosecutor, this guy, Craig Kowalski, how he improperly cross-examined people, called him a bully 13 times in closing. He said, in challenging the defendant's testimony on direct that a chair had tipped over during the melee and caused a thud, the prosecutor asked, so you're telling the truth and no one, so you're telling the truth and no one else is? After the defendant said, absolutely, the prosecutor then asked, and convenient that it made a thud as two other witnesses described last week, is it not? In addition, the prosecutor improperly posed numerous rhetorical questions that assumed a factual premise that the prosecutor knew the defendant denied. For example, the prosecutor asked, now, what did it sound like, Mr. Fahey, when you drove this boot down onto Mr. Boudreau's head? What did it sound like? After the defendant responded that it didn't sound like anything, the prosecutor asked, was it a crack like Mr. DeLuca described? That follow-up question drew an objection that was sustained, but undeterred, the prosecutor next asked, did it sound like a thud like the bartender described? No objection was lodged and the defendant answered no. And then the prosecutor asked additional rhetorical questions to badger the defendant, such as, when did you make the decision that you had to kill Mr. Boudreau? Trial counsel objected and the objection was sustained. But again, the prosecutor was not deterred, asking next, when Boudreau was there with his fiance at that table over there and you were looking over at them, did you say to yourself, I'm going to go take this guy out that night? I'm going to take this guy out that night. In fact, over the course of his cross-examination, the prosecutor asked some version of that question 12 times. The prosecutor asked the defendant if he understood how unbelievable his testimony sounds, and queried the defendant whether he really was going to stick to his story. The prosecutor also prodded the defendant to admit that he did not call 911 because he didn't want the police there, thereby improperly questioning him about his failure to contact the police. A final improper question came at the beginning of prosecutor's recross. At the conclusion of redirect, the defendant stated how horrible he felt about Boudreau's death and how the date of the incident was the worst day of his life. The prosecutor immediately asked, how often did you rehearse that line, Mr. Fahey? I mean, we've heard some version of this type of cross-examination by prosecutors before in trials that we've watched. I want to say that Ashley Benefield's trial in Florida comes to mind. But in this case, based on the things that I just told you, the appellate court decided that he needed a new trial, that he gets a new trial. And then they go on to talk about the closing argument. Prosecutor also made numerous improper remarks during his closing argument. The overall theme of the closing was that the defendant was a cowardly bully who had victimized a more vulnerable person, a 42-year-old father of two. In fact, during the course of his closing, hold on a second. One moment, please. In fact, during the course of his closing, the prosecutor labeled the defendant a bully 13 times. It is improper for a prosecutor to use insulting names designed to evoke an emotional rather than a rational response from jurors. So the appellate court found a problem with name calling. And it was exacerbated at the conclusion of the closing when the prosecutor displayed photographs of the defendant and the victim to the jury. The photograph of the defendant was his booking photograph. Unsurprisingly, that mugshot portrayed him in a particularly unflattering light. By contrast, the photograph of Boudreau was in an exceptionally flattering close-up of his face that depicted him smiling. When Boudreau's mother was asked to identify the man in the photograph, she said that the person was her beautiful son. To be sure, despite their limited probative value, the photographs have been admitted into evidence, and it's generally acceptable to refer to them during closings. Nevertheless, we agree with the defendant that by asking the jury to draw a contrast between the photograph of the bully and the curated photograph of the vulnerable victim, prosecutors improperly sought to invoke the sympathy of the jury. And he also excessively mocked the defendant's defense. For example, he urged the jury to cast aside this ridiculous notion that the defendant did not stomp on Mr. Boudreau's head. Although a prosecutor is free to marshal the evidence in the Commonwealth's favor and to explain why the defendant's arguments were unfounded, he should avoid mocking such arguments with the type of excessive rhetoric employed here. And he got a new trial. And in the second trial, he was convicted of, what did you say? Involuntary manslaughter. I need receipts on that, so I got to look it up. But he got a new trial. And I think he argued that the video didn't show him stomping on the head. The bartender was behind the bar. He couldn't have even seen it anyway. Here it is. DeLuca's earlier statement that the bar counter blocked his view is consistent with the testimony of the bartender, who testified that the bar counter obscured her view. Was the video doctored, proctored, Fanning Crawford? Tell me. I feel like we've seen it all and we still haven't. Hi, Charissa. Thank you for gifting 5 memberships. You're amazing. You're so amazing. I appreciate you so much. And then, because of course it doesn't end there, the prosecutor for Norfolk District Attorney's Office, Craig Kowalski, was publicly reprimanded by the Bar Association. They call it the Bar of Board Overseers, the BBO, in 2024 for his conduct during the Paul Fahey trial. So they can do a couple of different things. They can suspend you from the practice of law for a certain period of time. They can disbar you, or they can publicly spank you, or they can just do nothing and say it was unfounded. Here, they're publicly spanking him. And here's what they say. It is ordered that Craig Kowalski be and is hereby publicly reprimanded. A summary of the charges giving rise to the reprimand is attached to this order. And so he got a public spanking. This was in December of 2024. So this is after Karen Reed's hung jury. mistrial before Karen Reed's second trial, this prosecutor for the Norfolk DA's office is getting a public reprimand for the way he acted during the trial of Paul Fahey, which entitled Paul Fahey to a new trial in 2021. And it's very short, so we're going to read it. It's one page. The respondent stipulated to a public reprimand for engaging in trial misconduct as a prosecutor while on cross-examination and during closing argument, which was the sole basis for overturning the defendant's conviction on appeal. So he agreed to the public spanking because he was probably like, please don't take my law license away. Summary. Footnote 1, compiled by the Massachusetts Board of Bar Overseers General Counsel based on the record of proceedings before the board. The respondent represented the Commonwealth as an assistant district attorney at the trial of first-degree murder case pending in Superior Court. The respondent's prosecution theory alleged that the defendant had punched the victim in the face without provocation, then stomped on the victim's head when he fell to the ground. The crux of the defense was, in essence, that the defendant had been acting in self-defense when he made a split-second decision to punch the victim out of fear that the victim was about to attack him. On direct examination, the defendant admitted that he punched the victim, but denied that he stomped on his head. On cross-examination, the respondent asked the defendant to answer questions that went beyond the established limits of proper cross-examination by, inter alia, which means among other things, posing numerous rhetorical questions, some of which constituted badgering of the defendant. So just compare and contrast this to what it is alleged by Rosemary Scapiccio that Lally and Proctor did during the Miles King investigation. The withholding of evidence. I mean, not that it's a good thing, but this ADA called the guy a bully 13 times in closing. Is withholding evidence worse or less bad? Furthermore, the respondent made numerous improper remarks during his closing argument that were inflammatory and constituted an improper appeal for sympathy from the jury. For example, the respondent repeatedly called the defendant a bully and excessively mocked the defense as, among other things, ridiculous. The jury convicted the defendant of murder in the second degree, and he received a sentence of life in prison. The Massachusetts Appeals Court overturned the defendant's conviction and ordered a new trial solely based upon the impropriety of the defendant's improper cross-examination and inflammatory closing argument. Specifically, the court found the respondent's errors on cross-examination and in the respondent's closing argument were pervasive and in some instances egregious. The court concluded that the errors created a substantial risk of a miscarriage of justice and that the defendant was therefore entitled to a new trial with respect to the charge of murder in the second degree. The respondent's improper conduct during his cross-examination of the criminal defendant and in his closing argument during the murder trial violated the Massachusetts Rule of Professional Conduct 8.4D. On October 31, 2024, Bar Counsel and the respondent filed a stipulation in which the parties agreed that the appropriate sanction for the respondent's misconduct was a public reprimand. On November 12, 2024, the Board of Bar Overseers voted to sanction the respondent by public reprimand. That's it. That's what they did. And this is in 2024, December. I don't know who the judge was. Hold on. The judge, I think it was a female judge, I want to say. Anybody remember the judge's name that tried the original case? The name like Mary Connolly sticks out to me, but I'm not 100% sure. So if anybody knows for sure, let me know. Right. Why didn't the judge call him out for bullying the defendant? Oh, wait, we're in Massachusetts. Right. So the long-winded way of telling you that Fanning was involved in that and seizing of the video evidence, and perhaps he and Fanning Crawford could have been involved in perhaps doing something to the videos. That's what Paul Fahey alleged in the civil case. Very little about on the internet about this case, says Craftastical. And remember where else Fanning has been. Fanning was accused of by Karen Reed's defense team, tampering with the jury. He's the one who told the judge that one of the jurors was spotted in a VFW hall or American Legion hall talking about the case and kicked the juror off the case. No evidentiary hearing. Fanning also arrested Turtle Boy at his kid's bus stop. Fanning also quickly cleared Matthew Farwell in the Sandra Birchmore case and helped ruling it a suicide. Robert Devine spoke with or communicated with Sandra Birchmore on the day of her death. There's also a civil lawsuit pending. I'm not sure where exactly it is in the system. And Robert Devine is also a defendant in that, in addition to Matthew Farwell and his twin brother. How far back does it go? We're going to have to continue this with part 2 because I have some of some of Robert Devine's testimony to the post commission and the things that he said about Tiffany and Sandra Birchmore and the arrogance in which he sat there trying to get his job back. There's been no ramifications for any of this behavior for decades. And is it coming to an end soon? Is Rosemary Scapiccio going to be the one to bring it all down? Very interesting. Higgins' choice of lawyer originally. Oh, it is? Who? It was Burke? The same guy, Burke? Thanks, Archie. I'm not sure who you mean. Yeah, it goes back to the Salem witch trials. It was Tully and Fanning who went to Aidan's house. Right? Wasn't it Tully and Fanning? You know how I know? Because we have video. You want to watch the video of Aidan KEARNEY getting arrested on August 11th of 2023? I'm going to show it to you because it may renew your outrage. Fanning's in the video. He was there. Let's watch it. Thanks, Archie, for your 10. Real Steve says, this prosecutor is making more improper remarks than Judge Gilday. There's something culturally wrong in Massachusetts. P.S. We see you, Colleen Crawford. Thanks, Steve. Mopey, Massachusetts says, isn't that a long time before a reprimand? I don't know. I don't know how long they had it for. And so I just don't know how long they had been investigating it. I don't know what they were waiting for. If they were waiting for the retrial to finish, I just don't know. I don't know their procedures and how fast they do things over there. Thank you so much, Kimmy, for your Venmo. Says, for doing the Lord's work, as always, I W honorary masshole for life. Thank you. Oh, thank you. And Betsy said, I love me some whipped tallow. Thanks for the recommendation. Oh, good. I'm so glad you like it. I love it too. Let's watch the video of Aidan KEARNEY being arrested at his children's bus stop on October 11th of 2023. And remember why we're here. One of the reasons why we're here, because we're not done yet. This is the interior footage of the police cruiser of the Massachusetts State Police. I think this is Tully's cruiser. October 11th, 2023 at 8:52 a.m. Here we go. I think the audio doesn't start until, wait, unless my audio is not on. Hold on. All right, it does come on, so you might have to adjust your volume because it's kind of loud. It's louder than whatever else we've been listening to. All right, here we go. It's not you. The audio doesn't come on yet. Okay, now watch as they pull up in front of Aidan's house, where I guess he used to live. And you're going to see his children's butt.
This is right. He's got a next stop, right? Yeah, next one.
They're talking about his kid's bus stop. Look at the school bus. They're right behind the school bus. They come pulling up. Look how many undercovers and how much backup they need to arrest Turtle Boy.
Yeah, his kids are right here.
His kids are right there.
Yeah, no way, that's a street where we could just tuck right here. Yep.
And here he comes, walking away from his kid's bus stop. Walking towards them, and they...
What's up, my man? How you doing?
The bus has not even pulled away. He put his two little kids on the bus. This is October 11th of 2023. And they jump out of the car before his bus, the kid's bus, even pulls away. What if they're looking out the back window? I asked Turtle Boy that when I interviewed him on my channel. I said, were your kids looking out the back window? He doesn't think they were. Thank God. Imagine the PTSD they would have.
Here for a second. Come here for a second.
What?
You got a warrant.
For what?
You got multiple arrest warrants.
For what?
You have to talk to Norfolk about it. We'll just...
Can I close the garage door?
Yeah, you can in a minute. We'll take care of it in a minute. Yeah, you have 9 arrest warrants. You're going to talk to the Norfolk detectives, not us. We're just helping them out, and then we'll leave them. What? They know more about than me, dude. I don't know anything about it.
Am I going to Holden barracks?
Yep. So we're going to bring you to Holden for a quick booking, and you're going to go to Stoughton Strict.
Today, this morning. Yes. Can I please close the garage?
Yeah, we'll take care. Just act like a gentleman. We'll treat you like a gentleman.
So we have a couple search warrants too.
Search?
He's okay?
That's Tully who's talking to him. That's facing him. You're going to see Tully. This is all Tully. And then you're going to see Fanning.
He's okay?
In the house? No. Hold on, because I talk to this guy. Make sure you right.
Handcuffed behind his back. He's handcuffed now behind his back. If you're not able to watch right now.
You have the right to remain silent. You choose to speak. Anything you say can be used against you.
That's Tully reading him his rights.
You have the right to consult with a lawyer before answering any questions. If you can have him or her with you during questioning. If you cannot afford a lawyer or want one, a lawyer will be provided you by the Commonwealth before questioning at no cost to you. You may answer questions now or waive. It's okay. That means you give up.
He's like, it's okay. I get it. Yeah. This is Tully, who wears shorts all year in his skinny jeans, and Aidan wearing a Free Karen Reed sweatshirt on the day of his arrest on body cam.
I get it.
Good. Let me finish this. And your right to counsel and have a right to remain silent. If you decide to talk to me, you still have the right to stop at any time for any reason. You understand the rights of that case. Okay.
Yeah, I'll get you everything you want.
Yep. What's the charge? Intimidation of a witness.
Which witness?
So all the things regarding Karen Reed. So the McCabe's, the Proctors, Julie Nagel, picketing a witness, and conspiracy.
Picketing a witness?
Just take a left down Piccadilly.
With the intent to try to... Correct. We're going to get out of the road here. So
We don't want to create a scene.
So why don't we walk up to your stairs?
We don't want to create a scene. You pull up behind his children's bus, school bus. You got the truck that you two were in. There's 2 unmarked. It looks like those are their cars too, parked in the street, right? And then you're going to see another one on the other side of the street. Well, you don't want to cause a scene? Of course you want to cause a scene. You want everyone to know that Turtle Boy's getting arrested, because the second you speak out against the government, they're going to come for you. And they're going to charge you with 9 felonies for petitioning activity.
Just without too much.
Why don't we just go in my garage? Let's do that. Did you guys wait for my kids to get off the bus? On purpose?
Did you guys wait for my kids to get on the bus on purpose? And he's like, yeah. And remember, there were some emails that surfaced, right? In a FOIA request. Remind me. Who was emailing or texting about what time his kids would get picked up on the bus? Somebody was feeding that information to Tully. Anybody remember who it was and what the messages said? There's another car. There's another arm unmarked.
He said no. Just, that's his. You gonna go in?
Here's Fanning on the left side of your screen.
Just stay with him. I didn't want Brian to stay with him alone.
There he is. That's Fanning.
All right.
I didn't want Brian to stay with him alone. Who's the guy that's talking right now? Brian Tully's the one who walked with him in the house. Everyone says it was Kate Peter. Tully's the common denominator, says Scott. Are you afraid what Turtle Boy's going to do to Tully or what Tully's going to do to Turtle Boy? And who's this man speaking? Does anybody know? They got their lights on.
Yeah, he's
cars in the street.
He's by himself with them. All right.
There's a Ford Edge, of course. And that's it. That's the
We finally
the arrest video, just to remind us what happens when you speak out against the government. And he still has, I don't know how many are still pending. They wound up charging him with more than 9. I think it was up to 16 at one point. Monday morning is going to be the mega motion. I don't know if there's going to be any live streaming on it. I think it's been prohibited, but we're going to do what we can to try and cover that as best we can. So that's supposed to be the big mega motion to dismiss. Is supposed to be at 9 a.m. on Monday. Is anybody going to court for that? Yep. Wild Goose says they took 300 photos in Turtle Boy's home, every closet, every bathroom, every trash can. Didn't they seize his devices too, and all his computers and his kids' iPads and everything? And I don't think, does he have any of those things back yet? Sunshine says, Tully them deserve all the shite coming to him. Right. JP, why didn't you want Tully to stay with him alone? Right. Everyone says it. All roads lead to Tully. He has his nose and hands and everything, says Teresa. But do you think maybe, just maybe, Fanning is a little bit more involved than anybody thought? Fanning's the one who quickly cleared Matthew Farwell. He started out, he was from Stoughton too, right? Did they all go to high school together? Law and Disorder said, the way Turtle Boy was so composed, calm, and non-reactionary was great. I would have lost my shit for sure. Mike's plans on going on Monday. Fanning was on the left-hand side walking up the driveway. Yep, he hasn't got any of his devices back. And Irish Girl has jury duty on Monday in Dedham. Well, congratulations to you. You might be being called in for Lindsay Clancy. They're going to start jury selection on Monday on Lindsay Clancy. I guess that's what you're going in on. Maybe, unless there's a lot of trials happening. Lexi said, God, that video just reminded me of how much I hate it. Carrie said his daughter's bedroom, creepy. Wyoming Nana of 4 says, Tully Crawford, Kate Peters' fingers in everything. Thank you, LW, for your super sticker. Yep, BB King says, this is our taxpayer dollars, folks. The fugitive team, all in. The fugitive team, all in 4 words. Sue said, yep, it is Fanning. And 25 years on the job says, yep, that's the ticket. That's the ticket. It's Tully and Fanning. Oh, that's right. I'm sorry. Clancy is in Plymouth. I'm sorry. Forgive me. Yeah, too many cases, too many times. You're right. I mean, yeah, too many things in my brain. I don't know if there's a prohibition on live streaming like that. That court order was a little bit, it was a little bit hard to figure out. And so I don't know. Wait, so that Judge Belazos entered an order approving a motion from someone to live stream the mega motion hearing. Says, music to my soul. Does anybody know? Does anybody know? I'm sure that, like, the only thing law and crime, mega motion is what you meant to say. Yeah. I'm sure that law and crime or somebody, Boston 25, CBS Boston, it can be done. Let me know if you want to do a part 2 on this and keep digging into Fanning and Robert Devine, because there's so much more. The stuff with Fanning and the Karen Reed jury. The IA reports on Fanning. Devine's testimony. Cannone's argument. Let's watch this. Let's watch this. This is from March 5th of 2025. Apologies in advance. Apologies in advance for the voice of Judge Cannone that you're going to hear. You might get PTSD from it. This is from March 5th of 2025. This is when Alan Jackson was arguing that there was governmental misconduct and that Karen Reed's case should be dismissed because of that governmental misconduct, specifically talking about Fanning. And this is only 8 minutes, so it's not the whole entire thing. So let's watch this when Alan Jackson, smooth as butter, talks about Fanning. And it's titled by Court TV, Fireworks and Karen Reed Hearing Between Alan Jackson and Judge Cannone. This might be the same day as the grave concerns. I don't remember. This is March 5th of 2025. So here you go. Trigger warning.
That Lieutenant Fanning was in the.
So it kind of starts in the middle of a sentence, but that is the beginning. I just put this up here.
That Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that he has.
I'm just going to start.
Oh, look, there's Mark Betterow. I spy Mark Betterow in the front row next to Janet Reed and Bill Reed. And this is when Alan Jackson is arguing that John Fanning was in charge of the jury in Karen Reed's mistrial. And she's saying, no, he wasn't. He was in charge of all of the security operations that had to do with the trial, not the jury. And Alan Jackson's like, well, we didn't have a hearing, so we don't know. Like, where are you getting your information from? And she doesn't care because she's the judge and she can do whatever she wants. But just listen. I mean, sometimes this is so interesting to watch, knowing what we know now, to go back and watch what we were watching in real time then, and how much has transpired, and how you can get a totally different take on it.
End quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that he has.
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander.
You can hear her voice starting to shake. You can hear her getting very, 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 very nervous. She's got a point at Yannetti. This is the way we do it in Massachusetts. Yeah, that doesn't mean that that's the way it was done this time. Okay?
Of the extensive security.
Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us, we were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case.
I mean, I just took The Handmaid's Tale duck down, but anybody who's watched The Handmaid's Tale knows about the commanders, right? The commanders were like the head MFs in charge of Gilead, which coincidentally was headquartered in Boston. The commanders were the ones banging the handmaids by force because their wives couldn't get pregnant. Fanning was the supreme commander. McLaughlin told us that. McLaughlin told us he was the supreme commander of all the security operations. Fanning did not testify at either trial, right? Because I couldn't find any testimony from him.
Told he was the that citizens got in part of a security operation that here, not part of a security operation. McLaughlin told us. We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't, Again,
you were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well,
She really does not want the public hearing this. I have the transcript. You were told that at sidebar.
Your Honor, what we were told is what his title was. Commander of the Extensive Security Operations of the Court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Unetti and I asked the court to take evidence from Lieutenant Fanning. The court
I think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors. I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
She's just saying that he had no access to the jurors. And, you know, I guess at this point, Brennan was involved, right? Was Brennan involved at this point? I think this is 2025, yeah. It's in Brennan's papers that he had no contact with the jury, but nobody swore to in an affidavit. There was never an evidentiary hearing. Nobody ever called Fanning in to testify, which is what a real judge would do, right? Get him up there on the stand and ask him questions about his contact with the jury. That was never done. It's a Ipsy Dixit because she said so. Because she said so. And the way she said that, now that you know that he had no contact with the jury. I'm sorry, what? I don't know that. How do I know that? You didn't call him in here. We didn't have a hearing. It's like her saying, and we read the decision to this recently again. And a lot of people had never heard it before. And she talks about how Michael Proctor was hiding the video in his drawer. Where did that come from? She made that up too. Who told her that? Nobody ever called Michael Proctor in for a hearing to ask him if he had the Sallyport video in his drawer and just forgot to turn it over, similar to the way he did it in Miles King's case by just not turning over stuff to Lally, and Lally just didn't care. He didn't follow up. There was no system. So excuse me for not believing the prosecution when they just say, yeah, no, he had no contact with the jury, or the judge just says, yeah, he had no contact with the jury. No. It deserves an evidentiary hearing. They didn't get it. And just the way she says that is so wild. Now that you know that he had no contact with the jury. Read that again.
Move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson. Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
now
there
that
evidence
you know it's not true?
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
So we will move on from that, Mr. Jackson. We'll move on from that. So,
well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly witness. I'm sorry, defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason, because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case. And he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly. And the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror. That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
all right. So that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
That's where this just short clip from Court TV ends, but so many of you are saying you had PTSD. I'm just watching that. My God, man. Is Fanning more involved than anyone thought? He just got a little slap on the wrist. If we do a part 2, we'll read his IA report. We're going to look at his investigation into Sandra Birchmore and some of the reports that he issued in Sandra Birchmore and how he interviewed Matthew Farwell in a cruiser in a parking lot, and how deep the tentacles really go. because we're not done yet. We ain't got no quit. And there are so many people who are new to this case that don't know all the stuff that we covered 2.5 years ago. Archie says, not that lawyer. He represented one of the two brothers in future case of another beatdown death in Norfolk County, original attorney. Thank you, Archie, for your 5. I'm not sure what you're referring to, but maybe somebody else in the chat knows. JP says, well, many district judges in Mass seem corrupt. At least the appellate court seems to uphold law sometimes. Sometimes they did not do it for Kelsey Fitzsimmons. They certainly didn't do it for her. And they didn't do it with regard to the double jeopardy argument after Karen Reed's mistrial. But it seems like in the case of Paul Fahey, they got it right. And, listen, I've seen worse. Let me just put it that way. I've seen prosecutors behaving badly, and I've seen prosecutors behaving worse than that, and defendants were not given a new trial. So I found that Paul Fahey decision granting him a new trial to be very interesting. I hope you did too. Thank you, IW, for your super sticker. I appreciate you. Archie says, Fanning has a gross history, if you can believe it. Tully, too. Commonwealth versus Kevin Clapp. They're trying to shut him up. Still trying years later. All right. That's another rabbit hole. Who wants to fall into that one? Carolyn, thank you for your super sticker and for tuning in from down under. And Mopey, thank you for your compliment. All that time in rabbit holes and still a glow. Oh, thank you. It is whipped tallow. I'll link it to the stream in case anybody wants it. It really changed my skin. And it's like $30. It's amazing. Thanks for being here for 24 months. Resilient Speaks says, I love this channel. I love this channel. Thanks for being here for 11 months. You guys are the greatest. Thoughts, questions, comments, concerns. Let me know if you want to do part 2, because I have a lot more for you. It's easier to do it during the day. There was so much banging today that I couldn't do it because I would have been going insane. And so we had to start late. We started at 5 o'clock and here we are 2 hours and 41 minutes later. And we really haven't even scratched the surface. And so let me know what you think in the comments below and in the chat. And I would like to do a part 2. If you guys are interested, due to public demand, we will absolutely do it, because there's a lot more where this came from. So many people don't know the lore behind the Sandra Birchmore investigation by Canton PD, because Canton PD was the first on the scene. Sandra Birchmore's apartment was in Canton. It's great for Australians, the 5 p.m. All right. Oh, thanks for loving it here. Thanks, Anne, for loving it here. Don't forget, there's still 20% off all merch in the merch shop, 20% off your whole entire purchase for, I think, the next 2 days or so. So if you feel like you want some merch, go on over there, check it out. We got the I Went to Cancun with Attorney Melanie Little stuff that Grant Smith Ellis has been wearing because I sent it to him, and he's the reason that we have that. There's the It Strains Credulity. We've got the concert t-shirt with all the sayings on the back from Karen Reed's trials. We've got some new Block Island merch. Block Island is lovely this time of year with a great illustration by Hannah Boston. And we also have the Godfather stuff created by Brendan. And it says, I love you with all my heart. If I don't see you soon, I'm going to die. And it's got me as the Godfather with the marionette strings and whatevs. And the tie-dye t-shirts are so comfy. And that zip-up hoodie, the Bella and Canvas one, is like the softest thing that I own. Softest thing I own. Martina says, these connections run to underground somewhere. Yeah, so much. All right, everyone hit the like on your way out. I love you guys. Oh yeah, the trucker hats are also, they're like $11.99 plus they're 20% off $11.99. And a trucker hat in the summertime has its place, it's much cooler with the mesh on the back. Like I'm sweating right now in this hat. Stay cool, stay kind, stay classy. I love you so much. All of you, the moderators are amazing. Thanks to the moderators, tip your servers. I'll be here for the rest of the week. Tomorrow's Friday, so we got that going for us. I don't know what time we're going to start tomorrow. Maybe around noon. So make sure you just set your notifications. And yeah, there's Block Island merch in there. Oh yes, oh yes, oh yes, there is. Check it out. The link is in the show notes below. It says there's like a fire emoji, and then there's merch link. And get on over there. Make sure you click the coupon at the top that says 20% off, and you get 20% off your entire purchase. Listen, it's not Amazon. It doesn't come in 48 hours because they print it to order. They print to order. It's a third party resale. It's not me. I know, I don't do it. I don't run it, but you'll have it in about a week, and it's awesome. Okay. All right. I love you guys so much. I will see you tomorrow, probably around noon. So just look for me then. I love you guys with all of my heart. If I don't see you soon, I'm going to die, but I'm going to see you soon. I'm going to see you tomorrow. Okay. Peace out, you guys. Have a great rest of your evening. I love you so much. Bye.